Hi, Richard.
How are you, Sydney?
Great, thanks. I hope you and your family are doing well.
Yes, we are.
Good.
Thank you. And yours also, I hope?
We're all doing really well, thanks. It's nice to have some good weather to have everybody get out a little more.
No kidding.
Hello.
Hi,
Hey.
how are
Hey,
you?
Tom.
All right.
I got a thing of
And just, I moved Victoria over as a panelist.
Thank you. I must have gotten on the wrong link.
No worries. And we have Roger and Amy Dressler. Is Amy supposed to be a panelist as well?
Yeah,
Yes, okay.
yeah. Thank you.
Thanks, Beth.
You're welcome.
Hello,
Hi, Naomi.
I have my daughter trying to block out some of the light coming in from the side window.
You mean the skylight?
The skylight, yes. Thank you.
I'm breaking chair. That's what 120 pounds does.
It doesn't have to be too high.
And then we have CF is with a raised hand. Is that somebody who should also be a panelist?
I think that's Chris.
Is that Chris
probably
Foreman?
Chris, yeah.
Okay. Let me move him over.
Yes.
Hey guys, it's Chris.
Hi.
Hey, Chris.
Hey, how are you? Happy Tuesday.
Oh, thank you, thank you, thank you. They're now taller than I am, so I can ask them to do all sorts of things. I just say, can't reach.
All right.
Hi, Sydney.
Hello, how is everybody?
We're good.
How's the puppy?
Well, we have the old co-worker here tonight. She's getting some puppy respite.
My dog, I think, bit a wasp or something last night, went into anaphylactic shock, and then broke out in hives. So I spent the morning at the vet trying to figure out what's wrong with him, and that's what they came up with.
Oh, is the dog
Luckily-
okay?
Yeah, luckily last night I was like, this looks weird. Let's give him Benadryl,
Oh,
and it worked.
poor
But
pup.
yeah, I don't know what he got into, but hives on a dog is not a pretty thing. I'll tell you that.
I can't even imagine what that would look like.
Like blisters, like quarter-size lumps everywhere.
Oh,
And his face, he was like rubbing it on the carpet, trying to scratch it.
well, poor Lily is 13 and trying to put up with puppy chaos, and likes to have doors between rooms.
All right. We'll go ahead and get started. Looks like we're at 6:03, so we'll go ahead and get started. And I'm just going to read the checklist to ensure meetings are compliant with the right to know law during the state of emergency, just to get us kicked off here.
Great.
So as the district currently hosting the area meetings of Lebanon, Plainfield, and Grantham school boards, I find that due to the state of emergency, declared by the governor as a result of the COVID-19 pandemic and in accordance with the governor's emergency order number 12 pursuant to executive order 2020-04, this public body is authorized to meet electronically. Please note that there is no physical location to observe and listen contemporaneously to this meeting, which was authorized pursuant to the governor's emergency order. However, in accordance with the emergency order, I am confirming that we are providing public access to the meeting by telephone with additional access possibilities by video. We are utilizing Zoom for this electronic meeting. All members of this group have the ability to communicate contemporaneously during this meeting through this platform, and the public has access to contemporaneously listen and, if necessary, participate in this meeting through dialing the following phone number: 1-312-626-6799, or by clicking on a link at the web address www.gvshawks.org. We previously gave notice to the public of the necessary information for accessing this meeting, including how to access the meeting using Zoom or telephone. Instructions have been provided on the website previously mentioned. And if anybody has a problem dialing into this meeting, you can call 603-863-9689. And in the event that the public is unable to access the meeting will be adjourned and rescheduled. All votes or any votes that are taken during this meeting shall be done by roll call, and we'll start the meeting by taking a roll call attendance. So each member who is present as a participant in this Zoom will state their presence, and also if there's anyone in the room with you during the meeting, which is required under the right to know law. And if you could also just state, as well as your name, if you could also state your role here in the meeting. So whether superintendent, school board member, etc. All right, and I'll start. I am Brittany Pye. I'm the chair of the Grantham School Board, and Grantham is organizing the area meetings this year. And then I have several screens of people. So I'll have the members of the Grantham board just state your presence and your name.
Jody Poljasic, Vice Chair, Grantham School Board.
Denise Sullivan, sorry.
No one else in the room with me, sorry.
Yeah, Denise Sullivan, school board member. No one else in the room.
Christine Conroy, Grantham School Board. No one else is in the room.
All right, and then we'll have members of the Lebanon board.
Tom Harkins, Lebanon School Board, nobody else in the room.
Dick Milius, Lebanon School Board. I'm by myself.
Kristen O'Rourke, Lebanon School Board, and nobody else is in the room.
All right. And then the Plainfield board.
Joanne, you were muted.
Chris Foreman, Lebanon, Meriden School Board. And just FYI, I'm super sorry, but I've got a hard stop at 7 o'clock. And so I will be dropping off at 7.
Okay, thank you.
Vicky, you're muted.
All right, okay. I was trying to do the, like when you push down on the space bar and it's supposed to unmute you, but apparently that doesn't work. Okay. Vicky Ramos, Clue, Plainfield School Board, and I'm alone.
I'm alone too.
Okay.
And then we have, and then for anyone else who's here as a panelist, superintendents or business administrators, so on, if you could just introduce yourselves and say if there's anyone in the room.
Naomi Butterfield, facilitator. There is no longer anyone in the room.
Beth Beerworth, Business Administrator, Plainfield. There's no one in the room.
Sydney Leggett, Superintendent for Grantham. No one else in the room.
Tim Ball, Business Administrator for Plainfield. I live in Plainfield, in Lebanon. No one's in the room.
Amy Dressler, Director of Student Services for Plainfield, and there's no one in the room.
Joanne Roberts, Superintendent of Lebanon. No one is in the room.
Corey Leclerc, Superintendent of Plainfield. No one is currently in the room.
Okay, thank you all. I think we got everybody. All right, so our first agenda item is the approval of the minutes from the April 21st meeting. So folks had a chance to look over the minutes from that meeting. And if there are any amendments or changes to those minutes, this would be the time. Okay, so hearing none, we need a motion to approve the minutes from the April 21st meeting.
So moved.
So that was Christine, and we need a second.
Second.
And I think, was that Chris?
Yep.
All right, perfect. Okay, and then I will just read off names for the board members present, and if you can just say yay or nay. So we have Christine.
Yay.
Jody.
I'm sorry, yes, but quick question. Can Chris second that? He wasn't there.
I was there. At the last meeting, I was there.
Oh,
No, there was no Plainfield reps at the last meeting.
there was no Plainfield rep to the last.
Yeah.
Oh, well, maybe that explains it. Right.
I'll second it.
I thought it was the last one I was at.
And was that Tom?
Yes.
All right. So second
Sorry.
by Tom. Thank
And-
you for catching that, Jody. Okay, so Jody
Aye.
and Denise,
Abstain, I was not present.
Richard,
Yes.
Tom,
Yes.
Kristen,
Yes.
Victoria,
Abstain, I was not present.
and Chris,
Abstain.
and Brittany, aye. All right, so we have the approval of the minutes, and I will turn things over to Naomi.
Okay. Approval of the agenda is the opportunity for anybody who thinks there should be something added to this agenda. Or if we have something that you believe is covered, but are there any amendments or changes that anyone would like to see to the agenda? Okay, hearing none, I'm going to move on. We have a lot on this agenda as we did last time, but I really want to thank all three districts for really putting in a lot of work ahead of this. Grantham did a lot of work on the 504 IEP, as did Lebanon. And Plainfield, I really appreciate you getting some ideas down on the foreign students. I think this puts us in a much better position. And Lebanon sent out a letter on Friday, which was helpful because it summed up a number of those items and identified their position on those items. So I apologize, I have allergies. I do not have COVID, but I will be coughing, but no one else is in the room. I think, why don't we start out with going back to kind of where we got to on the IEP 504 issue. Where we left it last time was that the three districts would all reach out to council, and all three have done so, meeting with Drummond Woodsum, who prepared a memo of law or an opinion letter regarding apportioning responsibility when a parent files a complaint. He did a nice job, I think, outlining the issue and differentiating between the IEP process and 504 accommodations. Has everybody seen copies of that? Like, I'm trying to figure out sort of where to jump in and how much I should assume people have seen things.
Copies of what, Naomi?
The the letter, both from Jim O'Shaughnessy at Drummond Woodsum, as well as Grantham and Lebanon's thoughts about proposed language and apportioning liability for IEPs and for 504 accommodations when there's a problem.
I've seen all that material.
I
Okay.
have also.
You have not?
I
You
have.
also-
Yes, I
Okay.
have.
Naomi, not my board members have not seen that.
Okay. Can you forward that to them? When I send things generally to the superintendents and hope it gets disseminated that way. If there's a better way for me to forward those things, please let me know. I'm happy to send to everybody, but don't know always who's coming and don't have all the email addresses. But however we want to do it, I'd like to make sure everybody has as much of the information as possible. I can, excuse me, summarize briefly where I think we are. And then if during this, if you want to give me an email address, I can jump on and send it someplace specific. Drummond Woodsum essentially confirmed that, especially for IEP, the IEP process, the sending district, or the district where the child lives, is responsible for providing those services and would generally be on the hook for failure to provide those services. The IEP process is slightly different because it's an accommodation for a disability, and so the building in which they are attending classes and the receiving district may have more engagement depending on the fact. I think he made a good point that we talked about a little bit last time, which is that without facts, sometimes it's hard to look in the future at all instances and how those particular facts would play out. I think it was Grantham, Sydney, I think it was the memo that you wrote on the 15th, and I'll just hold up what I'm looking at.
Do you want me to pull it up, Naomi, for everybody, or do you not want me to do that?
Maybe in a minute, because I think identifying what would be most helpful for people to have the conversation. If you want to pull it up, that's fine. I just don't want to put you in the position of flipping documents really quickly, because I think that gets confusing. But the relevant sentence that I wanted to pull out of that, summing up Grantham's position, was their request that in the event the receiving district on an IEP, I think you put in both, but is out of compliance with the plan, and I assume that's the IEP, they will share equal responsibility in any financial and or legal obligations that result. In contrast, somewhat, Lebanon has identified that the law defines the respective responsibility of the sending and receiving school districts. However, they said we're prepared to discuss a section which more clearly spells out the respective expectations of both districts and allows for the districts to maintain a written protocol with regard to communication and collaboration. This draft revised April 21st, 2020 from Lebanon, I think was also an effort at putting out a protocol for making sure that the services are provided rather than looking at the other end if there's been a problem. I think right now that the conflict here is in two parts. And I think last time we talked a little bit about how do we avoid problems? How do we work collaboratively? Brittany, I think in the discussion last time at the end, you really looked at how to promote that collective approach and avoid being in a position where one of the sending districts perceives that there was a lack of compliance and their only with the plan, and their only avenue would be then to bring a lawsuit, which was contrary to the collaborative spirit of the area agreement. And to that end, I understand the memos from Grantham, that last sentence about sharing equally in the financial or legal obligations addresses that. The question I would have, and I kind of throw out there to all of you, is as the sentence reads, it says, in the event that the receiving district is out of compliance with said plans. I think that begs the question, how is that determination made? At what point is that determined? Out of compliance, you know, when you're in a suit or when there's a parent complaint, parent complaints, as everyone in this room knows, could be the IEP was deficient. It could be the IEP was fine, but I don't think I'm getting the services that were identified in the IEP. It could be there aren't services available and I need an out-of-district placement. So I'm not sure both how that's determined and also whether this is something that goes into the area agreement or whether this is part of the protocol. And so I'm tossing that out for discussion amongst you. Is there anybody who wants to speak to that? Sydney, do you want to address a little bit about what you contemplated in terms of how that would be determined, or how you would know someone is out of compliance, and if it wasn't a case-by-case basis?
Well, I think it's always going to be a case-by-case basis. You know, everything that happens is going to be what's individually happened with a student. So it could be any of the things that you just mentioned. Any of those things could happen. But there are some specific instances where, for example, something is clearly in the plan and was not being implemented in the receiving district. And those would be the kind of situations where we would talk about being able to, you know, share equally in the responsibility as opposed to having everything be on the sending district. I hope that the Grantham School Board's memo was clear about how the intentions were that this would benefit all districts, because it moves forward with a more collaborative spirit, and hopefully there would be fewer problems because we would all be working together, you know, as we go forward. So that's kind of basically where I know the Grantham board has been feeling about these instances. And the other thing is there is an element of vulnerability for the sending districts, in the sense that since we are always responsible for this, if something goes wrong, it really is on us, no matter what's been done at Lebanon. So
yeah, oh, sorry, go ahead.
An understanding, you know, that I hope that Jim's memo also cleared up.
So this is Chris from Plainfield. I just read the memo, so this is a bit of a hot read. You know, I think that there is a clear opportunity where two, you know, kind of parties could each think that they had the ball and the ball drops between them. There's also a responsibility that Lebanon has, you know, to you know, fully execute on a plan. And it's a challenge. My experience, the way these types of issues are dealt with between collaborative parties is the implementation of arbitration. So rather than saying, you know, we're going to go sue each other over something where we can't necessarily, you know, agree around, you know, where fault lies, or, you know, we interpret facts differently, is number one is a statement that we're going to work together to kind of figure out what happened. Secondarily is to implement, you know, arbitration in a, you know, we both have to agree, or the parties involved have to agree who's going to arbitrate it. But that seems to me like a fairly real and rational way to kind of mitigate any disagreement, because we don't want this, you know, we don't want this to get silly. And we all know the fact that special education sometimes, if things don't necessarily go right, can get really expensive. We also know that in spite of everyone's best efforts and everyone's attempt to stick to an IEP, sometimes there are external factors that push a district to have to spend a tremendous amount of money to meet the needs of kiddos based on the strongly held belief of parents, and that is the responsibility of the sending district. But if there is an honest disagreement about whether or not somebody dropped a ball on an IEP, we should have a structural way beyond just talking about it to resolve that before it gets to the point of real kind of real badness.
So Chris, could I ask a follow-up question?
Sure.
You proposed arbitration, which is a whole process, and the arbitrator actually makes a determination like you would have in court generally. And I'm wondering if there's something short of that that could be determining the limited question as to whether or not the receiving district was out of compliance, if the allegation from a parent is that the IEP wasn't followed and or the IEP was insufficient. Is there a way to modify what you're suggesting?
Step one is always to have the parties talk about it and endeavor to work through. But what I've found in certain situations is the fact that the next step is a structured arbitration process actually provides rigor to those discussions. Because at a particular level, as a community of school districts, no one wants to sue anybody. Nobody wants this to go bad at all. And so, you get to this point where it's like, if you honestly disagree and there's no additional step beyond getting lawyers involved and filing a lawsuit, which I don't really think people want to do, it sometimes, I don't know how to say this, politely, but there's an incentive for each side to have a more entrenched position, when in fact there's an intermediate step between going all the way and having an external party come on in. Maybe it's going to allow people to see the middle ground a little bit more thoughtfully.
And I ask these sort of just to drill down, because I'll tell you, arbitration lawyers are always involved. We get our hands in everything. But I
get that, but there is a public relations risk. There is just an emotional side. There's a difference between kind of going through arbitration and suing each other.
Well, there is, but it's essentially a different form of that. And I guess what I'm getting at is there a way to modify this that would be acceptable to the parties, such that it read more closely, like in the event that the receiving district is determined to be out of compliance after fact finding, or sometimes you can have someone give you sometimes when you're already filed something, you can have a settlement judge say, this is my initial read on something, or you can have a fact finder who listens to both sides, gets whatever evidence each side wants to give them, and they say, this is my determination. I don't know if that's an option. The other option is that you leave it silent in the agreement, and then you develop a process either outside of the agreement, or if the matter arises in lieu of bringing a suit. I throw all those out for your feedback.
One of the things that I wanted to just mention that I really liked sort of how they came together was that in the memo that we got from Jim, it talked about making sure that there's strong language for preventing these, that the first step and the first measure is, making sure that these things don't come to that point. And I liked how that paired with the language that we got from Lebanon for the protocols, the communication protocols, and the IEP and 504 protocols. And I think that could be a huge step. And so I think Grantham would love to see not necessarily those full protocols appear in the area agreement, because that seems like more of the specific stuff that we're trying to keep out of the area agreement. But even just a sentence or two saying that, communication protocols and 504 responsibility and communication and all of those things will be followed or revisited. Some kind of just statement, sentence or two about those things, because I think that would be really helpful for the districts to have a document that they can fall back on to help promote some of those conversations. And I know we do just have a couple of, I think there's just a couple of items in the 504 and IEP protocols that we would just like to look at more closely. But I think that just the general idea of those that Lebanon put forward pairs really nicely with some of the guidance that we got from Jim. So
maybe referencing it, that a protocol exists outside of, the protocol exists outside of the area agreement. Do you have protocols as an area committee on other items besides this, or are we creating a new category or a new reference manual, or is there someplace where this would live that already exists?
No.
Not that I know of.
Okay.
This is Joanne. I think, I don't know if Cindy, you can pull it up, but at the last meeting, we really didn't discuss it, but the protocols that were just referenced are listed. There was 1 through 4. And I believe what Chris and others were talking about was what we proposed as a section O, dispute resolution and settlement of disputes, which, if I may read, and while people find it, because this was in the letter shared by Lebanon, any complaint by any parties to this agreement arising out of interpretation thereof, not resolved after a conference of the 3 area superintendents and a procedure for which is not provided herein, may by agreement of the districts first be reviewed via a jointly requested legal opinion, either from counsel who does not represent any of the districts, if all districts agree in writing to waive the conflict of interest, by an attorney who represents 1 or more of the districts. Should a resolution not result from the review opinion, the matter may be referred to any of the districts to mediation. If still unsuccessful, any district may refer this to the State Board of Education, which shall hear the parties and decide the matter under the authority granted by RSA 186.5. So I think there's 2 pieces we're looking at. One
I
is
was
the protocol.
looking at, I think this was the protocols that I thought we were looking at. Is that?
So, okay, there's 2 separate ones. There's the protocols that we sent at the last meeting that got pulled up that are specific, and there's 4 of those. And then that is separate because I was asked to put together very specific protocols right from the start. And that's a couple pages long. That kind of is it's a logistics thing. If sending district does A, then Lebanon responds B, and it kind of sets up times and all of that. That's much more deeper, that's longer than the actual language Lebanon proposed to live in the agreement.
Right. And so for the purpose of trying to stay on the agreement part, I think developing protocols, we can come up with an agreement, small a, to develop protocols that then are not following the same formalized process as actually updating the area agreement. A reference, we can still discuss whether a reference is appropriate for the protocol piece and then talk about that separately to not take the whole meeting on the area. I think although I think correctly, Brittany, I too like Jim's focus on making sure this doesn't happen. So the protocols, I don't mean to brush them off as unimportant, because I think that's really where the work lies, is in trying never to get to a point. I guess the question, where there are costs, I guess the question is, do we need to address inclusion of language of cost apportionment or cost sharing if there is a problem? Because as Jim opines, and as Sydney has said, the sending district on an IEP is going to, by default, be responsible for those costs unless they are explicitly shared. 504 is a little bit different because it's an accommodation, but do we need to address that in the area agreement? And
I think Tom Harkins or Richard was going to speak to that for Lebanon.
I was going to speak to that, and I'm not quite sure what, I mean, as far as, I don't know what the question is right now. Are we talking about that one sentence about sharing costs?
yeah, I think what Lebanon's letter included was essentially very much more general, and the memo from Grantham had very explicit language that included that sentence.
Right. So I think what Joanne was, and Chris, well, so Chris was saying if there's a middle step between discussion and arbitration, and I think that's what Joanne was getting at. So that would be our preference, to have that in the area agreement, that section O, dispute resolution. So if there is an issue of like, all right, who is at fault here, we have that dispute resolution scenario, and then ultimately it's decided by, the Board of Education who is at fault at that point. And then my understanding is, and please correct me if I'm wrong, if Lebanon is found at fault by the Board of Education, then we would be responsible for financial obligations, if that is the case.
So Tom, this is Chris. I'm sorting through a couple things I just got. That makes sense. Does the DOE actually have? Can they do that? Do they adjudicate these differences between districts in that way?
No, they don't. That's part of the problem.
Yeah, go ahead.
So this is why, one of the reasons why we wanted to talk about it here, because you would have to agree that going into arbitration or those kind of things, that you would take that responsibility, because the DOE will follow the law, and the law is going to go back to the sending district.
The DOE determines the parent's complaint. If services weren't adequately provided, then it's on the sending district.
Yeah.
So to clarify, if what you're saying is, if a suit arises or a complaint from a parent that's going to DOE, if the parties went to the proposed dispute resolution process, would Lebanon, if there was a finding that it was a failure to implement, would Lebanon be willing to accept a liability that by law right now is on the sending districts? And I think that's the difference.
That's the crux. Yeah, I mean,
and that's the point. That's exactly the point, Naomi. That's the where we're sort of at an impasse. There is that we feel we cannot on our own accept a responsibility, whether financial or legal, that by law belongs with the sending district. And so when Joanne comes back to the general passage, section O, I believe it is, for dispute resolution, that seems to us to be a good place to resolve these specific problems when they come up. But to embed it in language that dictates how IEPs will be done, we feel that that's a real problem for us, because we have no legal standing in that matter. I mean, as you just said, the responsibility for overseeing the IEPs rests with the sending district, and it's not clear to us that we could even take on that responsibility.
But you're responsible for delivering the services, Richard.
I beg your pardon?
Can I jump in, Naomi?
I'm sorry?
Can I jump in and maybe rephrase the question?
Sure.
So I just want to rephrase it, because maybe this will help. How would Lebanon like to take responsibility, if there is responsibility on Lebanon's behalf, for an IEP finding of a complaint?
I don't have an answer to that. I think Lebanon would rather have clear and consistent communication about the implementation of the IEP and do everything we can in our power to make sure it is implemented correctly.
And then the question is, what happens when that doesn't happen? Because I know from Grantham's perspective, we feel as if we have a responsibility to our families, our kids, and also taxpayers when it comes down to that, that there are times where something doesn't happen and we're vulnerable. So, maybe just by turning the question that way, in what way, if Lebanon were to say, yes, we actually made a mistake with this IEP and this didn't happen, and we understand that, what would be the way that you would want to take responsibility for that?
So let me ask you a question. If there is, because I'm hearing what you're saying, and I'm wondering if there's another layer that before getting to the determination and the sending district's liability for attorney's fees, and there's another part of that, right, which is you got to fix it from DOE. Is there a place between the protocol that talks about how prospectively you will develop IEPs and communicate about IEPs and deliver IEPs, that when something is going wrong, that you could have a piece of a protocol in place to address sort of what you just mentioned, how do we fix this? My impression is that there haven't been, and please correct me if I'm wrong, because it's just my impression, that these suits that progress to the point where there are attorney's fees awarded and remedial measures imposed are few and far between, that they're generally settled. And that when you settle something, you can do it, you have a lot more flexibility in terms and apportionment. And I'm wondering if there is a way, a process, because that's really all we can decide at this point, is what process might there be to either address problems early before they get there, or once a problem arises, facilitate those type of settlement that would include, whatever terms you wanted them to include. But
then, Naomi, should that not reside in the protocol that we were discussing a few moments ago?
It could, yeah. I mean, this is your agreement. There's nothing in the agreement right now that addresses the question that we're trying to resolve. So the initial question was, do we need to add something? And if so, what should it say? And I think the issue has been for the sending districts, because we own this de facto, if there is an award, the award is attorney fees and some remedial action generally. There aren't damages awarded, except it sort of feels like damages when you're paying someone else's attorney's fees. How do we get help with that? If we feel that the problem that we got sued for was that it wasn't implemented correctly and we didn't have control over the implementation. So focusing on the let's prevent that from happening, I think, is where the bulk of it comes, and the protocols and the process for developing an IEP, evaluating the success of the IEP, and looking for ways to improve it if it's not working is clearly going to be the most of it. But I guess I'm wondering, how do we get through this impasse in a way that makes this workable? And part of that question is, do we need something in the area agreement? Do we simply have the settlement of disputes that when something comes up at that end is within that paragraph O, it would be one of the many disputes that could arise and could be resolved that way? Or do we include a paragraph of apportionment of or contribution of costs that is not otherwise provided in the statute. And that would have to be by agreement.
I don't see a scenario where Lebanon's going to be comfortable with including apportionment of costs. And I don't have an answer to your question, Sydney, except to say that the sending district by law is responsible. And Lebanon, like you said, we have a responsibility to our students and taxpayers and all that stuff. And once Grantham and Plainfield kids enter our school, we take them on as our kids, and everybody in the Lebanon School District is working to implement every 504 and IEP plan, which set up through this protocol and communicating and all that stuff will be monitored. You know how all that stuff works. But the law is set up in such a way that I guess by sending your kids to Lebanon, I don't know, I'm kind of just speaking freely here, but by sending your kids to Lebanon, you're assuming some sort of a risk that by law we're not responsible for and we're not willing to take on. And at the same time, we're going to implement the 504s and IEPs the best we can.
Yeah.
And then, so a couple of things, I mean,
Chris, the issue there is that then the only remediation that exists is we're going to sue you if in fact we feel that there's negligence, and nobody wants to do that.
I agree. And we don't
everybody
want to get sued either.
Every district is open to those types of lawsuits around, you know, if there's an IEP and it's not necessarily fulfilled, okay, there you go. I think Sydney's point about the fact that, you know, my question about whether or not the DOE actually is a body that deals with these types of issues, I think she made the right point. I don't think it is. I think it gives parents the right to say this type of stuff, but it doesn't adjudicate issues between districts, sending and receiving districts. And so all that we're advocating is, you know, add it to the end of what you're proposing, which is let's get a third party to help us solve this problem. If in fact, in good faith, we feel that Lebanon just, you know, the plan was to do A and you guys did B. Why would we ever want to get into a situation where we feel that we have to sue you? I mean,
can I ask, who would determine that we're out of compliance if it's not a law, like a lawyer and a lawsuit?
Well, that's the issue. Is if when you go to these things, there's two ways to deal with a dispute of facts. I mean, there's probably a handful of ways, but two common ways. One is if in fact you honestly can't, you've got a different sense of what the facts are, then you go to the courts. And what I'm saying is nobody wants to do that. You know, in the other way is you go to some type of arbitration, which is how we deal with our profession. You know, all of our union contracts have arbitration. You know,
yeah, but in that scenario, Lebanon has no seat at that table. It's between the sending district and the complainant, and Lebanon isn't.
No. What I'm saying is that in terms of apportionment of cost, like if we go to you and we say, hey, yeah, we legally have to write the check, but what we're looking for is recovery of expense.
But who determines we're out of compliance is my question.
Well, that's the job of the judge or the arbitrator or the jury.
So can I reframe this a little bit?
Is that not a lawsuit?
No, arbitration is not a lawsuit.
A what?
Arbitration is not a lawsuit. We're not suing you.
Well, can I back up just a little bit? Because I think the bottom line is that there isn't anything right now giving costs or for the receiving district to pay those costs. If the DOE finds that a child is not receiving the education they are entitled to receive. The sending districts are asking for something contractually to be added to have the receiving district contribute if they contributed to the problem. It doesn't seem like we are going to get to a place where that agreement is going to go into the area agreement, at least at this point. I think the point that was raised regarding the dispute resolution might be an option, in that if what comes out of this is a development of a better process for collaborating on the provision of services and the communication when there are bumps in the road on services, and then if there is a complaint filed and the sending district's position is, Lebanon, this was your fault, we want you to contribute, that's a dispute between the parties. And I think the dispute resolution paragraph could be how you resolve the dispute between yourselves, because
Isn't
Lebanon
that,
isn't.
isn't that middle step that Chris, you're looking for, that dispute resolution? That's like a mediation or arbitration, or I don't
No,
know.
it's
what's
different. It's not arbitration. It's
This is-
basically it's having a non-binding third party, and then it goes to the DOE, which isn't necessarily the right venue, it sounds like. And so, hey, listen, I don't think we're going to die on this hill. At least, Plainfield isn't, because we do actually have recourse. If in fact we think that it was material and wrong and bad, we'll just,
unfortunately, I think that's where we're at. Nobody wants to sue or get sued, but.
And so, the point that I'm making is that there is a very rational and reasonable way to avoid that, right? Because by saying, no, we're not going to do that, we're going to go through this process, the only recourse that Grantham and Plainfield have, if we believe that you guys are fiduciarily responsible because of negligence for this type of stuff, is we sue you. And that blows, and no fun. And so, do I think it's going to happen? No, because it hasn't happened in 10 years. But if the job of the area agreement is to think forward, it kind of seems like this is a fair point.
And it seems that we are the changes that have been proposed by all three parties, I think, would go a long way towards improving that situation. I mean, you're right, Chris. We're not in the habit of suing one another. I mean, that hasn't happened, at least not in recent memory. It hasn't happened. I mean, right now the agreement is silent on this, and I think when we're done with our work here, we will have a protocol in place, which will make it even less likely that a lawsuit will become necessary. And if we can agree on the generic terms for dispute resolution, I mean, it makes it even further away.
I say a little bit, just that I think one of the things that's important is to just sort of empathize with the sending district where there is this vulnerability. And I have to tell you that, we are extremely highly reluctant to discuss any cases, but I have, since I've been in Grantham for the last 3 years, had 8 instances where parents were going down the IEP OCR 504 road, and we have to deal with those pretty regularly. It's a regular part of our lives, and it doesn't mean that there's always fault in one place or the other. It definitely can lie everywhere. I totally agree with that. But the costs can really get up there, including, Jim had mentioned out of district placements. They can go up to somewhere around $275,000 if you're talking about sending somebody to high school. So this is a significant issue for sending districts, and the Grantham board intentions really was clearly to find a way where, from the very beginning, we all go in it together with shared responsibility, so that we do have fewer problems down the road.
I mean,
Please provide me with the list of 8. I'm totally unaware of a connection between OCR and our middle school or high school. And I want to make sure that I'm aware of these issues coming through, because I'm not aware of them as you've described. We have talked about a prior instance before you and I were even hired. There's a 40-page Department of not Department of Education, but a 40-page hearing decision in which Lebanon wasn't party at all. It was the sending district's lack of follow through. So I just want to let you know that I really do want to partner. And if you could send those 8 to me, I'd be grateful, because I want to talk through them and figure out what those issues are so that we don't have anything like that. I just thank you for mentioning it. I just didn't.
Well, I brought it to your attention.
Pull us back a bit
over
on
time.
So I think this speaks to the communication piece we worked on last time. It also speaks to the protocol piece, because I think being able to communicate when you get those types of threats, and I don't mean threats, I mean them as an indication that a parent is that unhappy.
Oh no, sometimes they are threats. It's okay. Yeah.
I think building that into the protocol, so the protocol isn't just aspirational, it contains some resolution pathways when those things arise, is important. I'm also wondering, just to keep us on track, because if we're not going to, if we're going to get in the rest of our topics, I think at some point we need to move on tonight. I'm wondering if there is some work that can be done on the proposed dispute resolution paragraph, such that it's a little more expansive. It's not just limited to the terms of the agreement, but it's the services provided within it, so that if you felt strongly, sending district, that the receiving district really owns a piece of this, and the only way that you're going to resolve it would be a lawsuit. That's essentially what the dispute resolution process is intended to resolve. So that if there was a piece that in one case you really felt that we're going to be committed to having to sue you to get contribution, you could use your dispute resolution process to resolve that and apportion contribution in that particular fact situation. What I'm hearing is Lebanon's reluctant to, in a contractual way, include that language separately in the area agreement as a de facto statement that we will contribute. But the sending districts would like that, because right now you're, the way the law is written, you're responsible for that child. Is there a way to resolve this impasse through building a process both to address those threats of litigation in the protocol, and B, maybe revisit the language of the dispute resolution so that it could include those kinds of disagreements?
Yeah, non-binding arbitration.
Mm-hmm.
It's admissible in court.
Yeah.
All right, so you know, you have non-binding arbitration, and so you have somebody that has fact finding. You go through this, and you know, if both sides don't like it and don't agree, and that's different than asking for a legal opinion from a lawyer who's going to be looking at the law that always reverts back to the sending district, and asking the DOE that doesn't do this.
Right, but a mediation might be one step in there. I'd like to get to some of the other things. Would it be helpful if, because it looks like we'll have at least one more meeting, if I were to play with a dispute resolution and settlement of disputes paragraph and send that out in the interim for comment, and see if we can't get to some place that could include disagreements about a particular factual situation in the future that had to do with an IEP.
So we're talking about the difference between, in the Lebanon language, mediation and moving that, changing that word or that sentiment to non-binding arbitration.
No, I was thinking a little more broadly. I was thinking in the first paragraph, in the first set, just expanding the way that this is written to include these types of conflicts if they're going to arise. And then proposing a process that so I think including mediation and keeping mediation in there is important. I take your point, Chris, about arbitration, but also from experience know that arbitration is essentially a trial in a different forum, which is heard more quickly by someone with more experience. But I think it doesn't necessarily engender the collaborative spirit and the resolution spirit that Brittany was talking about last time. It really is kind of like a binding trial. I don't mind if you guys want to get there. I just want to, I think we're a little bit at an impasse here with this particular two sets of language. I think it's important to move on to some other things and come back to it maybe next time, but not in an open-ended way. I think both sides have made their points very clearly, but I think there may be a solution in providing a robust dispute resolution process that incorporates these types of disputes, not just a dispute as to tuition or something else. That I think the way it's written is a little narrow, and I think maybe we could expand that. in a way
Just
that.
before we leave this, Naomi, just to be clear, which paragraph are you talking about making some changes, some new changes to? What we're referring to as paragraph O?
Yes, and there's two proposed, there's a language that Lebanon included, which I think came actually originally from Grantham. And the fact that it's pretty similar is positive. But I think we could maybe
So,
let
Naomi,
me just look at it.
Yeah, while you think about that, Tom, the primary, I think the primary issue in your language is in graph 1 where you request a legal opinion.
Yeah.
This isn't, the law is very clear that, you know, the sending district is responsible. What we're talking about is something, you know, that would probably fall under, you know, gross negligence or, you know, not following through, where we believe that there's a case that the IEP was right and we're paying you guys to do a job and you didn't do it. And so, you know, honestly, if there was a mechanism where it wasn't just a legal review, because I think that's probably the issue with the DOE and what's said there, but a review of all the facts about, you know, kind of liability. I think that probably is the backstop that would make the sending districts comfortable. Because it's not just the legality of it, it's kind of what's fair. So I know we've eaten all the time. I just wanted to, you asked the question and I wanted to make sure that was pointed out, that one word in the 4th line, you know, kind of stands out as probably being pivotal. Because if you ask a lawyer what the law is, that's a pretty simple thing.
Very clear, yeah.
Right? But if you ask them where the liability is, that's a different issue.
Yeah.
Well, and I'd like in some ways to get away a little bit from all of you having to go to the same council or get conflicts counsel and look at a resolution process, an ADR process to help you resolve that impasse. And honestly, off the top of my head, I can't rewrite the paragraph right now, but let me give it some thought. And maybe if each of you could think about whether using the dispute resolution process for these types of problems would be a middle ground and someplace we could get to that provides a pathway for contribution if it's warranted, if there is culpability, because that would avoid suing each other to go through a robust dispute resolution process.
Or essentially, we would be agreeing to saying, we'll have lawyers or some other third-party person look at like the whole situation in like a comprehensive way and decide who's at fault, and that will be binding, but it's not a lawsuit.
No, what I'm proposing is looking at this using an alternative dispute resolution process, focusing more on mediation, so that someone could help you assess what the risks and benefits and help you reach a settlement. That if the option is that the only recourse that a sending district has is to sue the receiving district, and it looks like there is some piece that they may prevail on in that particular case, the receiving district, Lebanon, could decide whether it's in their interest to contribute on that particular case or not. It's part of a, or let it go to court. But that there is some process that can resolve this with without putting that piece in. So
let's see what Naomi's language looks like.
Okay, because it is 7. We have a couple other things on the agenda. I think we could probably talk about this for another hour, and I think some of these other things are important as well. Plainfield sent out some language with regard to the foreign exchange students. Last meeting, there was some willingness from Lebanon to accept costs in a reasonable way of foreign exchange students. I think there were some proposals about maybe one, and we talked a little bit about timing. Does everybody have the language from Plainfield, or would you like me to read it, or do you want to put it up? What would be
Pull it up.
best? Okay. So while Sydney's pulling that up, my recollection and my notes were that we had a conversation about the benefits of having foreign exchange students, and the fact that the benefit is to both districts, that but how is that tuition going to be charged, and how is it going to be apportioned? And I think there was a recognition by all parties that there is a benefit to it. And so how can we all contribute to that? Are you able to pull that up, Sydney, or has everybody seen it? Okay, great.
Can everybody see it?
Yep.
And just to provide a little bit of color on this, I think that the reason why we provided an or here was truly to, you know, there's a couple ways to share an expense, and we didn't want there to be a perception that we were asking for a complete freebie from Lebanon because of, you know, we want to make sure that this burden is shared. And so, you know, from our perspective, either one of these would be great and would create, you know, the opportunity for all of us to you know, share in the benefit that these folks have without a massive economic penalty.
Grantham, can someone from Grantham speak to these two options and whether one or the other or both are attractive to you?
Yeah, I think, excuse me, I think we, you know, just in our conversations about what we would see, what we saw as fair and equitable, but also reasonable for the districts to take on financially, all of our options came in line with either one of these or both of them. And I think they would both be, for us, either one would be acceptable.
Can someone from Lebanon speak to your impressions of these solutions? And
can I ask a clarifying question just before we do that?
Sure.
What in both of these, what is meant by properly qualified? Is that relating to visa status, or is that some sort of academic reference?
I wrote it. This is Chris. The reason why I said that was so that there could be some outside of the agreement or even in the agreement definition of what that means. You know, one of the challenges that we have with exchange students is one of budgeting, right? Knowing when they're going to show up and if they're coming through an accredited program or not are the two issues that I think I've seen in the past. And so this was just an opportunity for us to define what that happened to be, Richard, so that it was a common understanding. You know, I don't think it's in anybody's best interest to have, you know, somebody's cousin come live with them at the last minute without budgeting, you know, not necessarily coming through a standard foreign exchange program. That creates budgeting challenges, and it may not necessarily be living up to the intent of what we're trying to do here.
Right, and we would the only thing I think that in that regard, we would just want to make sure that we're all on the same page with regard to just what criteria students have to meet, which is spelled out in the Lebanon policy.
Yeah,
you know, it's a pretty liberal thing. It's just we just want to make sure that, you know, perhaps to reference the Lebanon policy, which indicates just as you said, a properly qualified and vetted sponsoring institution, what kind of visas are acceptable and so forth.
I'm sure if you shared that, that would be acceptable with us. That was the intent.
Yeah, and certainly a reference to the policy that would indicate both the process for notifying Lebanon and how to define properly qualified. There is a policy, and if there needs to be some change to that, perhaps that's something that the districts could all look at together. So speaking for Lebanon, can one of you address whether, I mean, these are two good options. Is there a preference or a concern about either?
I think either one would be fine. That's what we discussed, I think.
I think yeah, go ahead. Joanne, were you going to say something?
No.
Oh, it was me, Christine.
Oh, hell. Okay, Christine. Go ahead.
I had a question about numbers. This is saying each district, one student per year. And the other option is all properly qualified students. I mean, isn't there some reasonable limit on numbers of foreign exchange students that are reasonable for the high school program?
Well, yeah, I think practically speaking, you know, I don't see any of our towns, you know, sending massive numbers, but that's kind of the trade-off is that, you know, if we get one for free, if there's a second one or a third one, we pay the full boat, and you know, it's a clear understanding. Or you know, if there's a couple of kids that come one year, we pay the half rate tuition. You know, I don't see probably either sending district, you know, kind of opposing some upper level cap. But the give and the get here is, you know, the balance between money guaranteed versus one for free and then full tuition after that. So, I mean, if there's an element to, you know, saying, hey, anything above, you know, X number, you need to get pre-approval from the Lebanon board. Okay. You know, I'm sure that that's a fair ask that both sides would be okay with.
Lebanon could take on.
We'd need to hear from Tim Ball on this. I think Tim is listening in as well. I think for budgeting purposes, the first option would probably make it easier for us. Tim, would you agree?
Well, I don't really, I guess I'd see it. I mean, I budget revenue based on who Plainfield knows is coming and who Grantham knows is coming. So if they knew that exchange students were coming, it's really 6 of 1, half a dozen for me, because they tell me that there's someone coming and it's free, then we just budget it that way. And I tell you that this is our revenue. It's basically extra revenue above and beyond the kids that are there. So I don't think, and our expenditure decisions are, you know, they're based on revenue a little bit, but mostly we you know, we usually put a budget together expenditure wise and then say how much revenue we have to match it. So I don't think it's really going to affect budgeting too much in Plainfield and in Lebanon, because we're not talking about expending, we're talking about revenue coming in.
And can I just clarify, I mean, there's two different types of visa programs. One of them requires contribution from the student coming. I'm assuming we're designating the type of visa that would be in this program. That is the
J1 or something like that?
Yeah, I think it's the J1.
It's in our policy.
Okay. Do we need to review the policy together with this language to see if one fits better than the other? I guess my other question would be deadlines and whether or not, to speak to Tim's point, there's a cutoff, because sometimes these programs really don't get you in a timely way. And what if they have a student who was in Hanover, but really didn't like their placement, it wasn't working out, they wanted to come be with a family who's in Grantham instead, and that comes in the middle of the year? I don't know.
Well, we would pick that. Well, assuming we're charging, we would pick that bill up in the next billing cycle because it would come over as an enrollment, and so that's why we bill 3 times a year with a makeup time in June. So that's how that would get caught in that scenario. That's how that would get caught. That's how it gets caught now.
So does that make one or the other of these more attractive to either the sending or the receiving district? Like if you used up your one qualified, where, in a late entry. I don't know how many you have a year, so I'm not sure how much of an issue this actually is. I don't mean to be creating complexity.
Very few.
There wasn't any for several years that I've been here. This is 6-7 years now, and we didn't have any for several years, but we've had a few in the last couple of years. So there's been very few over the course of the area agreement, but they seem to go in waves. And so the last couple of years has been, several.
I'm pretty sure we won't have any this year.
And if the agreement references our policy, what is it, JFAA or whatever it is, that allows for the Lebanon board to agree to accept an additional student if we thought it was in the district's interest and if it was necessary. I mean, it doesn't slam the door.
Okay. So what are people's preference? Do you want to leave those two out and you can think about it, take it back to your boards, and we can revisit it at the next meeting since they both seem attractive? Or
honestly, I think the ball's in Lebanon's court here. I think Lebanon should, this is both Grantham and Plainfield said we're good with either one of these. I think whatever works best for you, A, and B, maybe enhance it with your policy about what properly qualified foreign exchange students are so that we see it, and call it done.
Yeah, I just sent Naomi, Sydney, and Corey the link to our policy, so you have it.
Thank you.
Sure.
But I think that probably this is a unilateral. This is a unilateral decision unless there's a material change to the language for Lebanon.
Okay.
Man, if we could walk away with one tentative agreement out of today, I'd be delighted.
All right. So
Let's pick one, Richard. Which one you want? Kristen, pick it. Let's go one. Let's go with the first one.
Yeah, I agree.
All right. First one.
Woohoo!
Right.
All right.
Sounds good.
All right.
Sounds great.
Can I raise one small issue about that? We wouldn't, at least
Sure.
I know the benefit of these foreign students for my son who's talked about, he loves all these kids that come from different places, that we wouldn't want to, if you get one free tuition, the others you have to pay for, we just wouldn't want to discourage the plus ones. I guess that would be my.
Agree with that.
Okay. So we have about 15 minutes. Let's talk about transportation and then figure out another date. Transportation issue, I think, had to do partly, as I recall it, with the communication issue and how to communicate regarding bus schedules, delays, communication with parents regarding both. It seems every district in the state has some issues around transportation and finding enough bus drivers, but I think the issue here, if I am summarizing it correctly, was really about coordination and communication. Is that fair, or am I misstating it? Sydney, Corey? I can't remember.
I think this was Plainfield. Plainfield brought this up because Grantham provides its own transportation. So I think this was more from that sending district.
Corey, could you speak to this, or Victoria?
If memory serves me correctly, we there were sort of two layers to this. One is Plainfield provides our own bus for our high school students to attend Lebanon. However, if there are behavioral incidents on the bus, our Plainfield administrator doesn't necessarily have a connection with any of those high school students. So the question comes back to who addresses behavioral issues on the school bus. And then I think the second piece was currently Plainfield, pays for that bus. And I think we wanted to talk about costs of what it would be for Lebanon to run a bus, since my understand, I think you have your own bus fleet and you manage your own buses.
That's correct.
Okay. So then it would be a question around the cost of having Lebanon run that bus versus us contracting out with a different party.
I think it could be helpful to have clarification, Corey, because Plainfield's large. So if we were to look at costs, which we'd be willing to do, so you have a sense of that, would that be one loop, primarily picking up at Plainfield Elementary School and its parents' expectations to have their high school students pick up the bus there, or we add an additional route that's just over the line and that becomes a drop-off spot? I know that with the buses that we run, we've just done a review. Our buses are full, of course. I'm sure you are, many of yours are as well. And it's a matter of timing. So if you could maybe email me and Tim Ball and give more of a what kind of service would you expect? If it's a one pickup, we could give you a cost and a time estimate for that. I know that we couldn't expand our program to replicate many different bus stops within Plainfield.
Excuse me.
Bless you.
Thank you.
Corey, was this, and I guess this will come with more information, but in regards to the area agreement, which, Plainfield just sends kids for high school under the area agreement. So is this just specifically to the high school sort of transportation from Plainfield to the high school and back, or are you thinking more expansive, like Joanne was saying, like all of Plainfield to replace?
No, I just meant, sorry, let me clarify. I meant that we couldn't pick up high school kids throughout all of Plainfield. Not that we'd be providing transportation K-12 for Plainfield at all. So thank you for saying that.
I think it was just for high school students who are part of this area agreement. Could part of the area agreement also include transportation?
So right now, Plainfield runs a bus that's, so if you're a Plainfield parent sending your kid to Lebanon High School and you want to take the bus, you got to get your kid over to the Plainfield Elementary School. So you're talking about a replacement of that sort of service theoretically. Right, Beth?
So if I might, we actually pick up on the other side of Plainfield before the Plainfield school pickup. So we run a 120 and a 12A.
Didn't know that.
One bus, but it makes a very large loop.
Oh, okay. So that's a difference. I'm glad we're having this conversation.
Yeah.
Corey, maybe if you could send an email over to Lebanon with some more of the specifics, like what your loop looks like and how many drop-offs the ask would be, and what logistically that would look like in your mind, and what you would like it to look like.
And maybe ridership, it could be part of that. So on this big loop, I did make an assumption, but my child rides the bus from Plainfield, and it's like always empty. So I didn't even know it made these stops on the other side of town before it comes to the high school. So there's not that many kids doing it. So my point with the ridership thing is that, replacing a loop that's not being utilized is not cost effective for Plainfield, and it wouldn't be for Lebanon either. So I don't know if you could get some sort of stats as to how many people would ride the bus and from what part of town. That would be helpful too, I think, if that's possible.
So should we address quickly or initially the part 2, which is the behavioral issues on the bus and how to address those, since the kids are in the Plainfield bus, but there's not a lot of contact with them because they are being sent to Lebanon. This sounds like a communication pathway problem.
So, Naomi, if I can
Yeah, please.
chime in. So we had a meeting, I think it was not last year, but the year before, of the bus drivers and the administrators. And I believe what we came to the conclusion of is that the administrators at Lebanon, for us, the middle school and the high school, do the bus discipline. They keep us in the loop so that we can keep our drivers in the loop. And then if somebody loses the privilege of riding a bus, since they are our buses, if somebody's actually lost that right to ride the bus, then that's the sending district superintendent responsibility.
And finding out about the disciplinary issues comes from that sharing of information from including the bus drivers.
Yeah, we have write-ups on the bus, you know, so somebody would get written up on the bus. They usually drop those off at the GVS office just because they're coming there at the end of their route. And then they fax them or scan them up to the middle or the high school, depending on which bus it is, which kid it is.
Is that not happening, Corey, with Plainfield? And is there a way to implement a process in that regard that would address your concern?
To my knowledge, we haven't had any incidents this year, so I don't believe it's not I don't know how to say that. As far as I know, it's happening, because I think we just haven't had any incidents this year, but it was brought to my attention as something that has occurred in the past, and just using this opportunity to clarify how it's addressed.
Okay. So I have on the to-do that you'll get some information over to Lebanon so that we can more fully address the other piece about transportation.
Sure, I can get bus route information over to Leb for that part of it, sure.
And then we can address whether including transportation in the area agreement needs to be part of the area agreement or a side agreement as well. But I think we can't do that until we know which direction this goes and what they're looking at. Does that sound fair? Which brings me to 725. We still have kind of in addition to the wrap up, and thank you to Lebanon for including that terms of the agreement paragraph. I think that's a good one for us all to look at for next time, that contemplates a commitment to another 10 years, and how we do that. We were also going to revisit the sending district's participation in the Lebanon School Board activities, which is currently paragraph H in the agreement. And have a wrap up. I mean, I think we have maybe one more meeting unless something arises before then, or there's another piece that people want to revisit. What do people feel about trying to schedule this in June after school gets out? I think this year is all strange. I think when we started this, nobody was contemplating everybody being in one place, and vacation schedules were an issue, and trying to get it all done before people broke for the summer. That may still be somewhat relevant. Can we do something a little earlier in June rather than waiting a whole month? Thoughts?
I think so. If people could put out some dates, if Tuesdays still work the best, what that might look like.
How do Tuesdays in June look for everybody? How about the second Tuesday? Actually, before I say that, I should probably look at my calendar for the second Tuesday.
Works for me. How about other Lebanon board reps? Does that work?
Yeah, we talking
Wide
about
open.
June 9th. That's
June
the
9th?
Saturday. Yeah, that's
Sure,
fine with me.
sure, June 9th.
Okay. So let's get June 9th at 6 p.m. in the books. I'll get an agenda put together for that and try and get that out early so that people can have an opportunity to add to it if we're looking at that being a wrap-up. I'll try and get that out, you know, in a week or so from now.
Naomi,
Together with, yeah.
sorry, maybe you were just about to say that other language. Could you get that? Do you have an
Yeah, that's
idea
where
when?
I was going.
Yeah.
I was about to say, together with
Yeah.
some language on O so that we have some time before we go into it.
Do you know when you'll be able to get that to us? Because we are likely going to want to try and meet before that night.
Well, today's the 19th.
Yeah.
I can do it by Friday.
Great. Thank you.
That sound good? I'm going to do that with the early agenda with draft marked across it so that with the understanding that things can be added. Okay, because it's an early agenda. Anything else for the good of the order? All right, Brittany, I turn it back to you.
Okay. So thank you everyone for tonight, and we'll see everybody again on June 9th, and we just need a motion to adjourn the meeting.
Motion to adjourn. This is Tom.
All right, motion from Tom, and we need a second.
Second.
All right, from Victoria, and so we have a motion to adjourn in a second, and Christine.
Aye.
Jody.
Aye.
Denise.
Aye.
Richard.
Yes.
Tom.
Yes.
Kristen.
Yes.
Victoria.
Yes.
And Brittany, aye. And so we are officially adjourned. And thanks everybody. Have a good night.
So long, everyone.
Take care. Be well.
Thank you.